Wendi Adelson at this late hour has just made a bold legal move. She's now telling the court that she will only testify under the state's protection, the kind that shields her from prosecution. And the judge has now shut down her mother's defense team from questioning Wendi beyond what prosecutors want. In other words, Wendy's testimony in this upcoming high profile murder trial with her mother, Donna Adelson, as the defendant will be tightly controlled, and that could completely shape what the jury hears and does not hear. What's up, STS Nation? This is the show that brings you the very best guests in all of true crime, and we're on the breaking news, especially when it comes to justice for Dan Markel and all the Adelsons associated with allegedly and some knowingly taking his life away. In a breaking pretrial development, Wendi Adelson, the daughter of defendant Donna Adelson and ex-wife of the murder victim Dan Markel, who we just talked about, has now filed a motion to quash her mother's defense subpoena. Again, has filed a motion to quash her mother's defense subpoena. The state subpoena, conversely, grants her immunity. The defense does not. So this is important. Her attorneys argue that she would otherwise invoke her Fifth Amendment rights, meaning Wendy's attorneys, on every relevant question. Judge Stephen Everett agreed, citing precedent from the Catherine McBanawa trial, and ruled that Wendi will testify only under the state subpoena, with cross-examination strictly limited to what the state covers on direct. In open court, the judge compelled her testimony during the other trials, explained her immunity protections, and made it clear that she must answer all relevant questions under the state's questioning. Defense lawyers warn that this allows the state to tailor, if they do it this time around, her testimony, and will keep certain topics from the jury. The judge, however, apparently has stood firm. The motion, let's talk about that. What Wendi is asking for, the background. Both the state and Donna Adelson's defense team issued trial subpoenas to daughter Wendi Adelson. By Florida law, a state-issued subpoena automatically grants use and derivative use immunity. This means that nothing Wendi says and nothing investigators find because of her testimony can be used to prosecute her later because of this immunity. However, a defense-issued subpoena does not provide that same immunity. Wendy's position in this motion that was just filed, without state immunity, she will, quote unquote, according to her attorney, John Lauro, and I quote here, unequivocally invoke her Fifth Amendment rights on every relevant question. She wants the court to do the following. We'll break it down. Number one, let her make a formal statement on the record about her Fifth Amendment rights and her immunity under the state subpoena. Point number two in this motion, quash the defense subpoena. Basically telling Donna Sue Adelson, shove it. I am not coming to testify for you. Quash the defense subpoena entirely so she's never in a position to incriminate herself. It's the operative word or phrase, incriminate herself. It appears Wendi is looking out for one person, Wendi, and I wonder what that's doing right now at this hour to Donna and Charlie, who are starting to get wind of this. The precedent. This is the exact legal issue which came up in the Catherine McBanawa 2022 trial. The court at that time quashed McBanawa's defense subpoena of Wendi, limited cross to what the state covered, and the appeals court upheld that. So it happened before, and it's likely to happen again. Wendy's lawyers are asking the judge to, quote unquote, grant the same relief in this case. Now, you might ask yourself, why does this matter? For the state, it keeps Wendy's testimony under their thumb, under their control. They can avoid, the state can, avoid topics that might help the defense or expose her to self-incrimination. Now, on the defense side, this is a problem. It eliminates their chance to put Wendi on the stand during their case. It also restricts cross-exam to whatever the state chooses to bring up. And for the jury, they're going to now apparently hear a curated, state-approved, not defense, but state-approved version of Wendy's testimony. The subpoena itself, what about that? Her subpoena orders Wendi Adelson to appear between August 19th, that is the first day of jury selection, and September 5th. So the subpoena orders her to appear between August 19th and September 5th, 2025 in Tallahassee, courtroom 3G. That's where the big trials happen. That's where this trial is going down again. Now, it says she does not have to be there every day. The attorneys will notify her of the specific dates. Interesting. Guess Wendi doesn't plan on supporting her mom. And if reports are true and she's not in Texas, but now in Colorado, it's a long flight. So last time I remember, I think she came in and had to come back. She might want to stick around Tallahassee, the place her mother did not want her kids growing up in. Now, if she fails to appear when called, it is noted that she may be in contempt of court. Now, in a previous courtroom exchange, John Lauro, Wendy's attorney, said, and I quote here, this was at a previous exchange, previous court date. He said, without a state subpoena, Miss Adelson would unequivocally invoke her Fifth Amendment rights. The use and derivative use immunity would only apply to a state subpoena and not to a defense subpoena. He argues that there was no appropriate purpose in this previous hearing in calling her for the defense just to have her plead the fifth in front of the jury. At that time, Judge Everett granted that motion to quash a defense subpoena, saying that, and I quote here, cross-examination will be limited to whatever the state brings forth in direct. There's no piggybacking or bringing in other information. And Judge Everett is firm here. John Lauro confirms she will only, again, testify under the state subpoena. Defense attorney at that time, this was during Katie's trial, Tara Kawas warned that limiting cross lets the state, and she said, and I quote, this is Tara Kawas now, Katie's attorney at the time, that it would allow the state to tailor their direct examination to prohibit us, meaning the defense, from going into areas that could potentially be relevant. She called it a risk of, quote unquote, reversible error. Sounds to me that like it might be irreversible error, but it says reversible in this motion file. The judge noted her objection, but stood by his ruling. Now, in a second courtroom exchange, the immunity advisement, this is what this was about. Immunity advisement. State Attorney Georgia Kappelman asked the court to compel Wendy's testimony under the state subpoena. Judge Everett at that time addressed Wendi directly. He said to her directly, and I quote, the testimony you provide and anything derived from this testimony cannot be used against you, but you will be required to answer all relevant questions. Do you understand that? Wendi Adelson, yes, Your Honor. The jury was then brought in at that point. Strategic implications with this motion. The states win. This is why they win. They get full control over Wendy's testimony content. No risk of her refusing to answer in front of the jury. The defense's loss here. No chance to expand questioning beyond what the state covers. Potential impeachment avenues are cut off. And for Wendi, she gets maximum legal protection while still cooperating with the prosecution. Wendi. What is she so afraid of with this motion filed at this late hour, just several days before the start of the trial? So what do we watch for next? How narrowly the state crafts their questions to avoid giving the defense any openings, opening that proverbial legal door. Whether the defense can introduce certain topics through other witnesses or evidence. And lastly, and perhaps most importantly, how jurors will perceive Wendi, either as a cooperative truth teller or someone who is trying to shield herself from really tough questions. I think I know the answer to that. We'll see if the jurors know the answer to that. Again, the breaking news, Wendi Adelson's defense team filing a motion to quash her mother's defense subpoena. The state subpoena, meanwhile, grants her immunity. The defense does not. What is going on here? This is high-level chess. It appears Wendi Adelson might have something that she doesn't want to be revealed, and she wants to take no chances with getting up there and testifying for the defense. So she will only cooperate with the government. How strange is that, since her mother is on the defense here? Is this a family that is simply crumbling and in fear about what's to come? Time will tell. Love you, America. Love you, Tallahassee. Justice for Dan Markel always.